To go ahead and keep from having our Judge Ross, who's speaking tonight to us, to have to wait on too much longer. Thank him for coming in and for all those that are a part of the Criminal Justice and NAACP Forum tonight. We're going to go to God in prayer, and then I'll have Ms. Teresa to introduce our speaker for tonight. Shall we pray? Gracious Heavenly Father, we're grateful this night that you've allowed us to be here alive and well, and also again to be able to come to hear the presentation of our particular judges in our community, get to know them well, and God, always make sure that we have space so that we can do what we can as an organization to make sure that we are well within our rights and doing what we can to reform criminal justice, and also to see about making things happen better for our community. We pray your blessings that we will have a successful meeting tonight. In Christ's name, amen.
Amen.
All right, Ms. Teresa, if you would please introduce our speaker for tonight.
Yes, tonight we have Judge Brian Ross, who's from our State Court Traffic Division, and he is going to speak to us about his court and what happens in his court a little bit, and then also talk to us about any of the alternatives that he uses when cases come before him. Nothing specific, but to do that. And then to ask us for any type of community support that he would recommend to better the experience from State Court Traffic Division. I give to you Judge Brian Ross. He is also my Leadership DeKalb teammate and also real active in our community outside of being a judge. All right, Judge, take it away.
Well, thank you, Madam President, President Teresa Hardy, my Leadership DeKalb classmate in the class of 2018, the best class ever, and a good friend of mine as well, who I see in the community out and about working hard on behalf of the people of DeKalb County. Thank you for having me here this evening. It's really an honor to participate in this meeting. And I just want to take a few minutes, 10 to 15 minutes, to describe what we do on this DeKalb County State Court Traffic Division in particular. And like Teresa mentioned, how the community can become involved and some alternatives we have to the typical forms of sentencing, or how we tweak those just a little bit differently. First of all, I was appointed to the state court in 2015 by Governor Deal, and I was appointed to the traffic division. And by way of history, the DeKalb County State Court was created in 1951, initially with one judge. Now there are 11 of us. And the state court is a court of limited jurisdiction. The Superior Court is the general trial court of Georgia. They have general jurisdiction over matters. The state court has jurisdiction over misdemeanors, which are lower level criminal offenses, and over certain civil cases, typically the civil cases that are not exclusively reserved for the jurisdiction of the Superior Court. Also, we could issue search and arrest warrants and conduct preliminary hearings. But the bulk of our work is going to be the criminal side, the misdemeanors, and those civil cases. Now, DeKalb State Court is divided into two divisions. There is a jury division and there's a traffic division. 7 of the judges are on the jury division, 4 of the judges are on the traffic division. So although all 11 of us have the same authority as state court judges, the case assignment is based upon that breakdown, jury versus traffic. Much the way you might see another court, say Fulton Superior, a court may have a family division. And so certain judges may handle the domestic and family cases, but they still have authority over other matters. It's just to not assign those cases at that particular time. So in the state court traffic division, we handle most of the traffic cases that come to state court. Not all, but most. There are just a few that still are handled by the jury side. But the bulk of them are handled by the traffic division. And we handle the traffic cases for all of unincorporated DeKalb County, and then a couple of the municipalities as well, including the city of Stonecrest. Typically, it would be municipalities that either don't have their own court or their courts do not handle these types of cases. Stonecrest does have a municipal court, but they do city ordinances versus traffic violations. A court like City of Decatur, Stone Mountain, Lithonia, they handle their own traffic matters. So we do all of unincorporated DeKalb County and then a couple of municipalities as well. So, I mean, DeKalb being a very large county, that's a very, very large number of cases. Years ago, up until 2015, DeKalb had a recorder's court. That court was abolished. And in that process, the cases that the recorder's court handled were shifted. If they were traffic misdemeanors, they went to state court in the newly created traffic division. Ordinance violations went to magistrate court. And so that's kind of how we came into existence and how we handle things. Now, let me explain to you how a person ends up in traffic court, and then I will address how it worked before COVID versus what we're doing now in light of COVID. A couple years ago, if you received a citation or ticket, as many people call it, the citation would have on it a court date, and it would say report to court on a particular date and time and at a given location. You'd come to court on what's called an arraignment calendar. Now that's the calendar where you appear in front of the judge and the judge will formally tell you what the charges are that you're facing. Typically, it's going to be what's on the citation. Although, of course, the solicitor, who's the prosecuting attorney for the court, can amend the charges, that is, change the charges to something else. But generally, it's going to be what's on the citation. At that time, you'll have the opportunity to enter your plea. You generally have 3 plea options. You can, of course, enter a plea of guilty. You can request to enter a plea of no contest, also known as nolo contendere. I say request because that is within the discretion of the court as to whether that plea will be accepted. Or you can enter a plea of not guilty. If you plead guilty or no contest, then typically you will be sentenced at that time. And in most traffic cases, it's a fine only. There are some other cases some traffic cases that are more serious or that the law actually requires more than just a fine. And I'll go into those in just a moment. But in most traffic cases, it's going to be a fine only. You'll be sentenced, and then if there's a fine, you'll be asked to pay the fine. If you can pay the fine that day while you're in court, we'll say, go ahead and please take care of it. There are cashiers are located in the building, and they take multiple forms of payment: cash, cashier's check, money order, credit card, with a slight convenience fee. If you're not able to pay it, then we will give you some additional time to pay it, roughly in the range of 2 to 6 weeks, depending upon the size of the fine, as well as your financial circumstances. A fine may be $50, but you're not able to pay it then, but you say, hey, if you give me a week, I can take care of it. We probably give you 2 weeks. A fine may be $300, and you say, Judge, I need a full pay period, a full 30 days, and we might give you 6 weeks. But the goal is to resolve the cases such that people don't have this lingering over their heads for some very extended period of time. Obviously, in addition to having the option of pleading guilty or not guilty, as I mentioned, you do have the option of pleading, in addition to the option of pleading guilty and nolo, you have the option of pleading not guilty and going to trial. You can either have what's called a bench trial, which is a trial in front of the judge only, who hears the evidence and finds the facts and makes the decision from the bench regarding whether the defendant is guilty or not guilty. Or you can have a jury trial. A jury trial is where 6 individuals who are residents of DeKalb County hear the evidence and they decide whether the defendant, that person who received the citation, is guilty or not guilty. You can have either one. Because traffic cases are, and this is going to sound kind of strange to some folks, but they are criminal cases. That's not the case in every state. In many states, traffic cases have been decriminalized. They are not criminal cases. They are purely civil in nature. So if you violate a traffic law in those states, you can't be arrested for that. You can't go to jail for that. But administrative action can be taken against your license. You can lose your license, which is issued administratively through the state. In Georgia, traffic cases are criminal cases. The overwhelming majority, almost all, are misdemeanors. There are a couple of felony traffic cases, most notably vehicular homicide in the first degree. But most are misdemeanors and general misdemeanors, meaning that the maximum penalty for those offenses are a fine of up to $1,000 and up to 12 months in the county jail. There are some what we call high and aggravated misdemeanors, which would give the option of imposing a fine of up to $5,000 and it's still up to 12 months in the county jail. So, you could, at the arraignment, you make your decision whether you want to enter a plea of guilty or nolo, or whether you want to enter a plea of not guilty and go to trial. I'm glancing down at the chat. Okay. And so essentially that's how it works. Now, what we've done in COVID, we've made some modifications to that. As opposed to having large numbers of individuals coming to the courthouse in this era of COVID, what we have done is the officers still give you a ticket. The ticket still has the court date on it. But what we do is when the officers turn in the court copy of the ticket to us, which that's how we know they gave somebody a ticket, we intercept it and then we send a letter to the defendant. Of course, the address is on the citation and it's the address that appears on their driver's license. We send a letter to the defendant saying, do not come to court on the date on the ticket. We are not conducting arraignments in person. We do handle other matters in person, but not arraignments. Instead, what we'll do is we'll tell you to contact a criminal case manager for that particular division. And then that person will send you a Zoom link so that you can come to court virtually. And we found that to be very effective. Now, it's not 100% because, again, we mail the letter to the address that's on the citation. The address that's on the citation is the address that is in the Department of Driver Services DDS records. It's the one that's on your license. Now, as you may expect, some people don't keep their address updated. Even though the law requires it, they don't keep the address updated, but that's the only address we have. And you're supposed to keep it updated. So we send you that letter and then we tell you report to court virtually. And that way you don't have to come to court. We don't have dozens of people in the courthouse at one time. You minimize the COVID risk. But once we do have the virtual arraignment, everything else happens the same. You are told what the charges are. You enter your plea of no contest, guilty, not guilty. If you plead guilty or no contest, we resolve the case, hopefully that day. If you need extra time, we'll give you extra time. If you want a trial, we'll make a note of it. We'll ask you to put that in writing. Then you will be scheduled for trials. Trials do take place in person. They do take place in person, whether that's a bench trial or jury trial. And there are very specific reasons for that, including some constitutional reasons. You have a right to confront your accuser. So that is taken literally, meaning to be in the same room or confronting that person. And not only that, but people like to be able to see the witnesses, attorneys, the parties, they want to see the witnesses. The judge, we want to see the witnesses and the people who testify to help gauge their credibility, things of that nature. And also when we're doing trials, of course, it's a relatively small number compared with the hundreds of people who receive citations. So we can do trials in person and still maintain our proper social distance and things of that nature. So it's still a relatively minor COVID risk. So that's essentially how things work differently in terms of COVID. Now, what if you are a person who's imposed a fine, but just 4 to 6 weeks is not enough? Well, we do have probation in DeKalb County. And yes, people are on occasion placed on probation, even for traffic matters. But it's not as onerous as you might initially suspect. When you're on probation, I'll give you, say, for example, a 12-month probation sentence to pay a $500 or $1,000 fine, because just a month and a half is not enough. And certainly we understand that. The thing about probation is that probation will terminate. I put in the sentence, the order, that the probation terminates as soon as you take care of the fine. So if you just need 2 months to do it, once you pay it off within 2 months, the probation has terminated and the case is closed. You're off probation. Okay, our goal is not to keep people on probation or any other type of government supervision any longer than necessary. So that is why we have implemented that as a court-wide policy. Also, if you are unable to pay, you will have the option of working community service in lieu of fine payment. And there's a list of companies that have been certified by the court, typically nonprofits, sometimes governmental agencies, where a defendant can go work community service. And for every hour they work of community service, they'll be given a credit against the fine amount. So they can work off the entire fine amount and not incur any financial penalty whatsoever. This is helpful to some folks if a person may be temporarily out of work, not due to disability or anything like that, but they just are kind of in between jobs. Their money is not what they would like it to be. They can take that time to work off their fine via community service. Now, it's still important that if you are out here and you committed a traffic violation, whether it be hit and run or driving, 90, 100 miles an hour, I mean, certainly you have to be held accountable for that, but that does not mean the penalty should be harsh or severe. So we try to avoid that. That's it in a nutshell. I'm going to, at any time, I will continue my remarks, but I want to turn to this question in the chat. And at any time, if anybody has any other questions, please don't hesitate to speak up. So the question in the chat is, with traffic cases, is the administrating office still required, I believe that should be officer, still required to come to court to prove the traffic ticket? Okay, so if a defendant requests a trial, in these cases, as with any criminal case, the burden of proof is on the state. The state is represented by the Office of the Solicitor General. In criminal cases, the burden is proof beyond reasonable doubt. So the state would then decide what evidence do they need to present to the finder of fact, whether it be the judge or the jury, to prove its case against the defendant beyond a reasonable doubt. In many cases, that would require them bringing the officer who issued the citation. In many cases, the officer is the witness as to what occurred. However, I will note that in car accident cases, typically the officer did not witness the accident. In fact, it's very rare. Usually people just don't get into accidents right in front of the police. The police are called to the scene to respond to an accident. Now, in the case of speeding, sometimes the person may be charged with running a red light. Well, the officer was there, they saw it, they can testify to their direct knowledge of what happened. That's generally not the case in a car accident. Two people get in an accident, there may be injuries, somebody calls 911, the police show up, ambulance shows up. Then the police at that time talks to the parties to kind of determine what happened, and that officer may issue one or more party a citation, but it's not based upon his or her witnessing the event. It's kind of based upon his deducing what happened based upon the statements and the physical evidence. Where was a particular vehicle damaged? Are there skid marks on the road? Things of that nature. So long story short, yes, the state has to produce witnesses to prove its case against the defendant. So let me point out, and again, I'm happy to take questions. Let me point out that DeKalb County probation, state probation, is a government office. In some counties, cities, they use private probation. What I've seen and what has been found over the years is that when you use a private company for probation, they generally have a profit motive because it's a private for-profit company. The government does not have a profit motive. And so what has occurred in some instances over the years in certain places is that there have been abuses by probation departments in that they were quick to seek arrest warrants on individuals and to otherwise revoke or modify their probation for individuals who do not pay either the fine that was imposed or the probation supervision fee. Because typically for-profit probation companies receive their revenues from the probation supervision fee. Now, in DeKalb County, since we use a public probation company, no one is arrested or has their probation revoked or modified for not paying the probation supervision fee or for paying the fine. As I mentioned, if you cannot pay the fine, there are still ways for you to satisfy the terms and conditions of probation. And they include working community service in lieu of the fine payment. So by having a public probation company, we've eliminated one of the areas that was most frequently abused in traffic courts throughout the country. I'm sure you've all heard some of the more extreme examples. And so it was a good thing, I think, when the traffic matters were taken from the then recorder's court, the recorder's court was abolished. Traffic cases are now being held by state court, and state court has a public probation system in place. Recorder's court did have a private probation company. And I'm not saying those abuses occurred there, but there was obviously, in my opinion, a greater potential for it when there is a company that has a profit motive. All right, are there any questions before I continue? Well, Teresa asked what can be done in terms of the community offering assistance. Well, let's go back to the probation question. One thing is, if you have a nonprofit that you think provides a valuable service, you can submit your company's name to the court for consideration for a place where people can perform community service. We have a list already. We have government agencies. Keep DeKalb Beautiful is on there for litter abatement and things of that nature. But it's always good to have more options for folks because not everything is suited for every person. Some folks, they don't want to be outdoors. Maybe they can't be outdoors because of allergies or other issues. And so working, community service outdoors is not suitable for them. Some folks may need to be, have something they can do on the inside, an office type situation. Some folks have different interests. You may want to work with keeping the community clean. And so if you have something along those lines, it's something that can be considered, but you'd have to submit the information to the court for consideration. And again, it'd have to be a nonprofit, not a for-profit company, but a nonprofit. And certainly we would consider that. Do they have any questions?
It's a good point, Judge Ross. I don't think we have had people come to us to do community service. I'm not sure if we're on your list, but NAACP is on the list as well for service.
Okay, that's awesome. Okay, there's a question in the chat. How do we submit for our corporation or nonprofit consideration? I will provide my email. Well, my email address is bkross@DeKalbCountyGA.gov. I'll type it in the chat. And certainly you can send it to me. I'm typing it right now. Okay. The next question is, due to COVID, most of the officers are not taking offenders. Hopefully this will open up. That brings up the point that there has been a decrease in the number of arrests during COVID. Obviously, everyone is taking this very seriously. Sheriffs throughout the country have reduced the number of folks who are being taken into custody or being held. That's because folks are at particular risk in confined areas such as jails and prisons and things of that nature, where they don't have complete freedom of movement. They don't have there's more restrictions. And so we've seen officers exercising more discretion in terms of making arrests. We may see more citations being issued versus people taken into custody and being placed in jail. And officers do have discretion on many matters, particularly traffic matters, regarding whether to do that. There are some offenses that do, even traffic offenses, that do carry with them, if you're convicted, mandatory jail time, including driving without a driver's license or driving on a suspended license. However, in most of those cases, the jail time can be suspended or probated, meaning you would not actually have, you would have to be sentenced to it, but you would not actually have to serve it. It can be a suspended sentence or 10 days, but served on probation. So it would not require you being in custody. So when we find that there's a person who is convicted, either through pleading guilty or being found guilty at trial of an offense that typically would require jail time or some type of documented record of the person being convicted, we might, in lieu of having them serve time in jail, we might require them to go to the jail to be fingerprinted, so there would be a record of the offense, but then to be allowed to remain out. In other words, just go in, be basically being booked, but not being held. So there's a record that you did commit the offense, that you pled guilty to, or that you've been found guilty of, but then you are released, and so you don't have to serve your time. Now, typically those are folks who, you may have been the first incident, first time you were caught driving without a license or driving on a suspended license, where there is a mandatory 2-day jail sentence. What we will do is we will sentence you to 2 days in jail, but we'll suspend that jail time as long as you get fingerprinted. So by a certain date. And of course, we do have to give you a date certain, otherwise, some folks would just never do it. But we'll give you 2-3 weeks to go to the jail, get fingerprinted. As long as you do that within the time specified, you don't have to serve the jail time. And that's worked out well for folks. Again, folks, you are being held accountable for what you have done, but in most cases, you've taken responsibility for that. And so nothing would be served necessarily by, making you do a weekend in jail or anything of that nature. Now, what we saw before COVID more commonly was that a person charged with driving on a suspended license or driving without a license, they would be arrested by the police. And so then they bond out quickly, typically within 4 to 8 to 12 hours. So by the time they came in front of the court, if they pled guilty, we would not have to order them, sentence them to go get fingerprinted because they had already been booked upon their initial arrest. And so there was a record of the offense at that time. So at that point, we would just be whatever the statutorily required fine was. And in many of these cases involving the license, it's a steep fine. It's $500 even for the first offense. But we would just impose the fine. We would sentence them to the mandatory jail time, but I'll give them credit for having already served that on the basis of their arrest at the time of the offense. So I have found that there are fewer jail cases. It's being reserved for the more serious cases, for the felonies, for the probation violations, and not so much for the traffic offenses. And perhaps even not as much for the lower level non-traffic misdemeanors. Now, of course, there are violent misdemeanors, just like there are violent felonies, battery, assault, particularly in domestic cases, and those folks are arrested. But most traffic cases certainly will not fall into that category of seriousness, even though they are both misdemeanors. Traffic cases are misdemeanors, and battery is a misdemeanor.
All right, everyone, is there any other questions for Judge Ross at this time? You're welcome to come off of mute and speak or type it in the chat.
One other point while we wait to see if there are any other questions I want to make is people should not assume that that the case has been pre-decided. I've actually had people come in front of me and say, hey, you know, what difference does all this make? Why would I want to go to trial? You're going to find me guilty. That's as though the case has been prejudged. I mean, nothing could be further from the truth. In bench trials where the judge makes a decision, I've found what some would consider to be a surprisingly large percentage of people not guilty. I've acquitted them. And I say some, but those are the folks who assume, well, you know, I'm going to be found guilty no matter what, especially if it's just the judge, you know, making the decision. That's not the case. The state still has to prove its case. They have the burden. Sometimes they're able to do that. Sometimes they're not. And I was most recently, before I became a judge, I was a felony prosecutor myself, and I handled a large number of cases. And so I want people to realize that they have the opportunity for a day in court. It will be a fair day in court. You have a chance to be heard. If you want a trial, you can have a trial. We'll try to make it happen as quickly as reasonably possible. If you don't want the judge to make the decision, ask for a jury trial. It's no problem. That's your right. It is your right, and we will accommodate you. And so I've always been somewhat surprised at the reluctance of people to do that when they steadfastly maintain their innocence. And I don't know if they think they're going to just not get a fair day, a fair shake at it, or whether they just don't want to come back to court. And I can't do anything about that. You know, if you have a trial, it's going to happen in court. It's not going to happen in your living room. So, but again, you have these rights, you have these options. I would encourage you to exercise them, and you'll be given a fair shake. All right, let's see. There is another question in the chat from Mr. Speakman. The question is it hard to rule without prejudice when someone is unruly because they believe that we found guilty? No, it's not hard, Mr. Speakman. It's not, because I just base all the rulings based upon the facts and the law. I've seen a lot over the years. I've been licensed to practice since 1999. I was a felony prosecutor for many number of years. I did criminal defense work for many number of years as well. I mean, I've been called every name in the book. And so, I mean, it's a part of the job. It comes with the territory. And I've people who have been very unruly have gone to trial in front of me on a bench trial, and I found them not guilty. Because how you act in court has nothing to do with whether you committed the offense or whether the state can prove you committed the offense. Now, if you go beyond the boundaries with it, you are subjecting yourself to being held in contempt. But again, that's not the underlying charge. And that's rare, very rare as well, people actually being held in contempt. You'll find more people being admonished that they may be held in contempt than folks actually being held in contempt. It's very, very rare. You'd be surprised. Now, I know we've all seen these court shows on TV, not only the fictitious ones, but the ones that show real footage. Now, some of those things you see in real court settings, they're over the top. Obviously, it's going to be a problem. I mean, if someone comes over the podium and tries to attack the judge, that's not generally going to endear that person to the judge. But that, I mean, I've never seen that in person. I mean, certainly it happens. But that's generally not the case. But no, it's not a problem at all. We just kind of separate. You know, we have a lot of cases, and we just have to make sure everyone has a chance to be heard and fairly dealt with. We do ask that people follow certain rules of decorum just to facilitate us handling the cases. Now, if you're in court back in the days before COVID, when you had a large number of people in person, I'm talking to defendants, the prosecutors are talking to defendants, the public defender is talking to his or her clients. If you have, if you're being disruptive, we may ask you to step outside, just outside the courtroom, not outside the building, outside the courtroom. Let's say you don't make a phone call. You can make a phone call. You just can't do it in court while everything is going on, because people can't hear what's going on. You need to step outside and make a phone call, go to the restroom. You have a baby with you, the baby is restless. You know, feel free to step outside. We'll try to, actually what I do is, I don't know that I should announce this, but when people do come to court with a baby, I put them at the front of the line. you know. Now, I'm not encouraging you to bring your baby to court, you know, if, you know, feel free to do so if you want, because it's open to the public and babies are fine members of the public. But I put them first because I know, we all know what young children can become, you know, they don't want to just sit around and they become restless. And so we handle their parents' case and then move on to the next case. So the baby doesn't get upset, start crying, things of that nature.
Awesome. Thank you so much. The reason why I asked that question is because I pastor inner city, inner city church with inner city youth. And some of them believe a lot of times that they're found guilty before. And especially with the way things have gone on with some of the police cases, we are feeling that way. So I just like to hear that from some judges to know that this is how you ought to act anyway going into court so that those things won't happen to you.
Yeah, and that's definitely the case. And I mean, it's going to be based upon the facts and the evidence, but I believe generally just, and I'm sure you do as well, I mean, you should comport yourself in a certain way.
Right.
Generally, no matter where you are. I mean, in church, I know, well, when I was coming up as a child, you dressed a certain way. In church now, I'm not saying, I know churches are more progressive in that sense now. Come as you are, right? And that's fine, because it's not about what you're wearing. But we used to wear our Sunday best. Now folks are more casual, and that's fine. But even with more casual, that doesn't mean that you get carried away with it, that you're showing everything on your body and things of that nature. I don't want to get on my soapbox, but you should govern yourselves accordingly at all times, irrespective of where you are. You know, you're out in public. You don't have to be the loudest talking person in the store, you know, at the restaurant. You know, engaging in using profanity at all times. I mean, you just need to govern yourself accordingly and give respect, you'll get respect. But in terms of the law, and I realize that people have not always been treated fairly and are not always treated fairly, but there's a remedy, hopefully in most cases, to that. If you find that, I'm told people come to court and they say, well, the officer treated me unfairly, or the prosecutor is not negotiating with me fairly. And I'll tell them, I said, well, listen, if you have a complaint about this officer, there is a way to address it. You can go to this officer's department, police department, sheriff, whatever department he or she is with, and have your concern addressed. If you have a problem with this prosecutor, here's the solicitor for DeKalb County. You can reach out to her. You can reach out to one of her supervisors who's over this person in the courtroom and have that issue addressed. I've told people, now nobody has told me they've had it in front of me has told me they had a problem with me, but I've told folks, if you have a problem with the court, there's a way to address that. You don't have to wait until the next election and get somebody to run against me. There is a commission called the Judicial Qualifying Commission, which has the authority to investigate judges who have violated the rules of ethics. And that includes acting inappropriately in court. So if a judge is out of pocket, there is a way to address that as well. Okay, if you think that the judge has violated some rule of ethics, now that's different from if you don't agree with the sentence or agree with the outcome of the case. You have appellate options for that. But in terms of violating some rule, you're being treated differently because of your age or race or gender or sexual orientation or something of that nature, or the judge is constantly yelling and screaming, not giving you a chance to be heard, something like that, that would go to the JQC. And, you know, the option is there. So I want everybody to know that there's an option to have your concerns addressed, but there's an appropriate fashion to do that. Just like if you feel the judge does not like you because he doesn't like the way I'm dressed, or he don't like my hairstyle, or whatever, the right way is to not curse the judge out in court. That's the wrong way. The right way is to go to the JQC, say, hey, this is what I was wearing, or this is what I saw the judge do or heard him say, which would suggest that he has some improper bias against me. That's how you address that. Make a record. Just like on appellate cases, I mentioned, when we started, Bert, I think you asked, did I mind being recorded? I said, no, I'm recorded all the time, and there's a record. You can go up on appeal to the appellate courts because there is a record of what's happening. There's a recording. Okay, so it's open to the public. You can come in there, sit. You don't have to have a case. Come in there, sit and watch and observe. If the word gets out that some judge is out of control, treating people unfairly, let's say the parties are reluctant to make a complaint. Well, just go in and watch yourself. You can make the complaint if you see something that warrants it. Yeah.